¿Presente en línea? Si no hay gente en línea, está bien. Va a tener que ir. ¿Qué cosa? Yo ya estoy en directo ya. Ya estoy en directo ya.
Esto no puede.
Okay, good morning, everyone. I think we have to start the next session. So this is my great pleasure to welcome you all on this panel on science-driven. You can sit here and I will call you. Yeah. On science-driven corporate climate responsibility, from voluntary action to legal obligation, co-organized by the Philanthropy Cortes Solari, the MERI Foundation, and Université Côte d'Azur. As the global climate emergency intensifies, the private sector is undergoing a profound transformation from self-regulated climate pledge to frameworks increasingly defined by science-based targets, regulation, and legal accountability. This shift reflects the growing recognition that credible, transparent, and enforceable climate action is essential for both planetary stability and long-term business resilience. This panel will examine how the private sector is evolving from voluntary climate commitments to legally binding obligations, informed by the latest scientific evidence. As the climate crisis deepens, science is increasingly shaping corporate responsibility, moving beyond pledges and disclosures toward enforceable, measurable action. The first part of this event will discuss how to go from voluntary leadership to shared accountability. And I'm pleased to welcome on stage Professor Petra Mainero. She is the director of the Durham Center for Sustainable Development, Law and Policy, so please welcome. Professor Grégoire Leray, who is professor of private law at Université Côte d'Azur and vice president for research at the Faculty of Law and Political Science, And Hala Mourad, who is the executive director of Dibin Association for Environmental Development in Jordan. Please come. So my first question will be for you, Petra. How has corporate climate responsibility evolved over the past decade?
Hey. Thank you very much. Thank you for inviting me to this distinguished panel. It's a pleasure to be here, and it's nice and warm. I have one slide prepared, but it does not have to be up there. It's really, it doesn't have to be up there. So I would like to take this opportunity to answer your question and point out that there are perhaps three strands of action or development lines along which accountability and voluntary leadership and responsibility of the corporate sector evolve. So the first would be around voluntary reporting. This relates to the Science-Based Target Initiative, CDP, other frameworks where companies are reporting to meet their ESG standards. And the second then would be reporting that is mandatory for those corporate actors who want to participate in the voluntary or the compliance carbon markets that we already have. And here's a great possibility for science to come in to drive, especially as we move towards Article 6, a global compliance carbon market, where we see a combination of elements of the voluntary carbon market and the compliance carbon market. And that is not without risk. So maybe we can explore that in the conversation here. And the third strand of action or development would be how states are now under an increased obligation or a clearly articulated obligation by the International Court of Justice and the International Tribunal for the Law of the Sea to regulate the activities of private stakeholders. And so I think it's three different strands of action. And overall, what we see is a move towards a more holistic approach to reporting, but also backed up by regulation to ensure that this reporting really happens. I think that's something we see for sure in the European Union, for example.
Thank you, Petra. And then we will move to the second speaker and the next question. So what role, Grégoire, what roles has science played in driving this evolution?
I have 10 minutes directly. You want to go ahead?
Oh.
Thank you, dear Chairman. I would like to start saying that it's a great honor to be here, and I want to warmly thank the organizer. So I will answer this question by examining the role of private law in this development. You can pass. As you may have noticed, just on a slide before, I have shifted the general title from responsibility to liability, because multinational corporations are no longer simply expected to behave responsibly. They are progressively subject to binding legal duties. And this movement made possible by the growing mobilization of private law in these matters. It is actually one thing to have ambitious international climate agreements, but quite another to identify their concrete influence in reality. And this influence can be observed through the penalties provided by the national laws, especially business laws. So private law is undergoing a phase of adaptation, not only in European Union, even if in particular in France, business law are probably in advance compared to other places in the world, but this movement is global, and several academic works bear witness to this trend. I have some references that you can read just close to me. The first one is a book written by an American-Italian author called Ugo Mattei. He's a professor in California State University, Turning Point of Private Law. The second one comes from Spanish-speaking America and is dedicated to, I think, in my perspective, it's the first book probably in the world dedicated to environmental private law. I can give you several examples. So this movement is not only localized in European Union, it's something global. And corporate climate liability in multinational firms illustrates perfectly well the hope we can have in contemplation of this movement. Over the past decade, corporate climate responsibility has undergone a profound transformation because of the emergence of a scientific consensus about climate change. So what began as my colleague says just before as a largely voluntary movement driving by, in business law, CSR reports, climate commitments, and soft law guidance, has progressively shifted toward a mandatory model where companies are no longer merely encouraged, but required to align their strategies with climate science and planetary boundaries. You can go. So I would like to present very quickly the general scene and focus after on one specific topic, some climate cases in Europe against oil companies are very full of, they teach us a lot of things about this movement. So first, you know probably this picture. It was taken in Dhaka in 2013 in Bangladesh, where a big building collapsed, killing more than 1,000 people. It was probably the ugliest face of globalized economy. And very quickly, some legal consequences were taken because in order for this phenomenon not to happen again, and especially in France in 2017, we adopted a new bill, we passed a new bill, la loi sur le devoir de vigilance, duty of care law. And this one was enacted in order to force large companies to control their supply chain and in order to make them avoid human rights violations and environmental damages. But little by little, this law and the European directive dedicated to the same subject adopted last year includes now present the climate change aspect. So most of the mechanisms I will talk quickly now are not totally new because they came from soft laws guidelines, such as the United Nations Guiding Principle on Business and Human Rights, such as the OECD guidelines for multinational enterprises and responsible business conduct, especially the last version of from June 2024, I think. And so 3 different kind of business law reactions illustrates the role of private law in climate change, and especially the way scientific consensus can help lawyers to improve the way climate change is seriously taken in internal laws. So the first one I was talking about, and is still behind me, this French law from 2017 is a first one in the entire world, but followed by other countries such as Germany. Germany decided 3 years after to have the same kind of bill you can pass. And some other countries, especially in the Western hemispheres, but not only, South Korea, Thailand, Turkey, maybe we'll have the same kind of law in next years. You have behind me a list of countries who already pass this kind of law. On an European Union perspective, we tried last year to adopt the same bill in order to force the 27th country of European Union to act the same. It's a very sensitive political situation because we adopted this directive in June 2024, and 3 months after that, European Commission decided to change a little bit this directive because of some pressure, because it's seen by some people as something which will condemn European corporate firms. How could I say? Even in French, I lost my word, but competitiveness. Because of course, this kind of law have some effect on the economical results of a firm. But so I will talk about in 2 minutes about a few cases dedicated to duty of vigilance law, but I would like now to talk about another and well, you can pass the next one. Another orientation very quickly, because on this second orientation, there's quite no evolution. It's too recent, but in the same movement that leads European Union to adopt a new directive about due diligence, we adopted last year another directive 2 years ago now called CSRD, dedicated to transparency. Now, and it's something totally mandatory, the big European firm have to be have to adopt some reports and especially some transition plans. So it changed fundamentally the nature of climate transparency, because some articles of this directive are dedicated to this subject. It didn't exist just before. So companies must now disclose not only their GHG emission, but also their transition trajectory, as I just said, mitigation strategies, and alignment with the 1.5 pathway. The last thing I wanted, but this directive is threatened too, because we will see during the next months what remains really about the text. For the same reason I just talked about the due diligence directive. You can change the, thank you. And the last thing I wanted to talk about before focus my point on some examples is the consumer law. Because from now in USA, in UK, in European Union, and probably in some other places in the world, I haven't worked from now on them, consumer law is probably one of the main pillar of this climate integration movement in law. In France, several courts have targeted misleading carbon neutrality advertising against Total Energy, against EasyJet, and some other companies. In the Netherlands, the Consumer and Markets Authority has developed some of the strictest guidelines in Europe, obliging companies to substantiate climate claims with verifiable evidences based on scientific consensus. Exactly. And so now, for maybe 2 minutes, if I still have time, I'd like to focus on some cases. So my point will be focused on what I know the best, so French laws and European law, but I have to cross borders in order to talk about what happened in Netherlands since 3 or 4 years. So the first cases who illustrate probably the best how judges now have to appreciate climate conscious, scientific climate consensus is the French, one of the 2 or 3 main cases against Total Energy, you know, the big French oil company. 2 of these cases are based on the loi sur le devoir de vigilance, so the duty of care. No, I will find my word again, but due diligence, French law. There are 2 major cases. One is a specific project that is targeted. In this case, oil exploitation in Urganja and the 2 projects linked to this exploitation, Tilenga and ECOP. I don't know if you heard about it, but it's a huge oil infrastructure in Tanzania and Uganda. Leads Total Energy to be sued in France. And another one is a perspective more overview, because some NGOs and some cities around the world, like New York cities and even I think New York State, sue Total Energy because they criticize the company for not adopting a strategy compatible with the Paris Agreement. And there is a last action still pending before the Paris Court of Justice against BNP Paribas. You know, BNP Paribas is one of Europe's leading financier and the world's 5th largest financier in fossil fuel development. And this action is based on the law I was talking about due diligence, la loi française sur le devoir de vigilance. So what is really interesting in these different cases is that as part of their argument, the plaintiffs are attempting to demonstrate the company's failure to exercise due diligence in light of the work of the IPCC. Maybe we can, just before you change the slide, if you want, I think I saw you, I think some of you did that, but this QR code links you to something else. I will take just 1 minute to talk about it, because it's from now, as I said, the 3 French cases I was talking about are still pending before the French jurisdiction. And from now, for what I know, there is only one climate case against a large company who receive probably a final point. And this one took place in Netherlands. It was led by not Client Hearst, but Milieu Defensie, an association, climate association in Netherlands, who decided to sue Shell for the same reason. Some plaintiffs sue Total Energy in France. And so what is really interesting here, that it marks, in my perspective and in many other opinions, a turning point. It was the first decision to impose a legally binding emission reduction trajectory to a multinational oil company, granting the duty in both human rights law and climate science. And what is probably the most interesting thing in this decision is that the judge ordered first, not in appeal, but first, a 45% reduction in greenhouse gas emissions, scope 1, 2, 3 of Shell. So as I said, on appeal, if Shell's liability is confirmed, the judge doesn't set a numerical target. But all in all, this case and the other one demonstrates how voluntary commitments become a judicially enforceable obligation that courts use to evaluate whether companies act in accordance with scientific necessity or not. So maybe some words as a conclusion. What role has science played in driving this evolution? If you read the different plaintiff briefs, you can see quite the same kind of argument. And it's the same in Netherlands, it's the same in UK, the same in France. I try to synthesize this demonstration just behind me. So what could I say that? Plaintiffs typically use IPCC report to argue that first, the risk is universally, the risk linked to climate change is universally known. Companies cannot claim ignorance of climate danger. Two, the necessary reduction pathway are scientifically established. Companies that fall outside their trajectories knowingly contribute to foreseeable harm. Three, the carbon budget is finite. Delaying mitigation increases the probability of violating human rights or environmental obligation. And four, scope 3 emissions are absolutely essential because the IPCC shows their decisive role. Companies cannot exclude them from transition plans. So I have many other things to say about it, but I don't want to monopolize the... So in conclusion, just one thing. In terms of science-driven climate law, let us trust in the judge's intelligence in the face of legislators' inaction. That's what I could say.
Thank you. Back to the chair.
Thank you. So before giving the floor to Ala, I would like to come back to Petra. If you want to add some words on...
Yes, sorry, I didn't realize. I thought it was a question. So maybe can I just ask in the audience, are you overwhelmingly scientists, lawyers? So a bit of a mix. So yeah, okay, it's both. So what I would like to do then, I won't take another 10 minutes or so, but maybe 5 to 7 minutes, something along that, to maybe just point out where I think we need to work together as a science law community, because there is a real potential here. So we've already said, you know, this voluntary reporting, it works to some extent, but it will not entail reducing emissions, because for that, I think we need a regulatory standard. So one option or one opportunity that we shouldn't miss is Article 6. Article 6 has these two different instruments, Article 6.2, where we need bilateral agreements. We've got already over 100 countries, bilateral agreements that exist that will be implemented through voluntary approaches, projects through which we generate carbon credits. And then there's the Article 6.4 mechanism, a sustainability mechanism that is governed by the SPM, as you know, overseen then by the CMA. And there are a lot of standards and regulations already in place for this mechanism. It's about to be implemented, which can be a really good thing. It can lead to transfer of knowledge, to wealth increase in developing countries, but it could really also be a huge risk. And I say very briefly why. So normally these voluntary carbon markets, they also generated credits through projects, but then it was for voluntary reporting for self-imposed standards. Now this credits that we will see emerging from Article 6 will be used for demonstrating achievement towards countries' NDCs. And in these new NDCs 3.0, they do mention we will make proper emission reductions, but we will also use for unabated emissions Article 6. So we will compensate. Now that can only work if it is in line with the science. Now we know most of these internationally transferred mitigation outcomes must be real, verified, credible, additional, permanent, or at the very least developed under a framework of non-permanent. So even for a lawyer, that is not very concrete. What is that? There can be reversals, and when you look up in the standards, there is a risk that reversals will not be fully addressed. So if we now think about the carbon cycle, the long-term carbon cycle, most of the emissions we are looking at in terms of carbon credits, emission reductions, will be avoided emissions. We will be using things that are already part of our net calculation, unless we see an additional removal from greenhouse gas emissions. We can only ever claim a slowing in the increase of emissions, not really a reduction. Yeah, unless we've got a balance of emissions in the atmosphere, we cannot claim we have reduced emissions by compensating them. Unless we open up a new sink, a completely new forest, that may work. But then also you need to address what happens in 30 years when this forest is no longer there and has set free against carbon emissions. So that is one point, really, to work quite closely with those experts on the expert panels that the SBM has already established, to find out which projects generate proper credits, and how do we then in the accounting ease this or alleviate this risk that there could be an overestimating. Because we know this from the CDM, it hasn't worked there. We need to absolutely acknowledge which projects are we looking at, and are they really generating proper credits. So that, I think, is a task for science to come in to help those who are making these rules, and also to help in how these projects will then be monitored. That cannot be just done by lawyers or policymakers. We need scientists on the grounds who help with the measuring. So that's the first point. The second point is the advisory opinions both said due diligence standards for regulating the emissions of the private sector. I think the ICJ actually is much clearer there in saying that the failure to do so can be a violation of an international law obligation. And these obligations are erga omnes. So that means there can be state responsibility. And for that to emerge, you only need to see a violation of the obligation of conduct. You don't need to have harm. Yeah. So when you can prove that a state has not done what it should be do at its utmost capacity to reduce emissions and to regulate the private sector, then this due diligence obligation to regulate the private sector could be violated. So I think, again, science and law needs to come together to define what is the standard. When are emissions unlawful? At what point do we see this tipping point? Because, of course, the ICJ also said it's not the emissions as such that are unlawful, but violating through emitting an underlying obligation. Now, ITLOS also said we need to regulate private activities, and due diligence of states, due diligence obligations are really important where it is about the emitting activities of the private sector. Just because harm occurred, says ITLOS, does not mean that the state has violated its due diligence obligation. So again, here we need scientific experts to say, well, can we still say a state has really done everything that it should have done, or would that not have avoided the harm? Yeah, so we need to understand again, where is the threshold? When are these emissions unlawful? Like, if you one last case that is really interesting in terms of how specific science, do I still have time? It's 2 minutes, where specific science, and in this case, attribution science, has made a difference. Not so much for the outcome of the case, and I think we shouldn't worry too much sometimes, because all these cases, even if they're not absolutely positive in favor of the claimant, they still tell us a lot about, for example, how we can better understand causation in the science, in light of the scientific evidence. Now, in this case, it was a case of a Peruvian farmer, Leah against RWE, which is the biggest German energy provider. And it was a case brought under a section of the civil code, and saying that through the emissions of this big energy provider, you can measure and quantify this contribution of this energy provider, was an increased risk of a glacial lake flood outburst. So the court in this case acknowledged that the emissions have causally contributed to this increased risk. Yeah? They said we don't even need to hear expert evidence for that, because we know since 1960s, through widely available evidence, that emitting large amounts of greenhouse gases significantly and measurably contributes to climate change, and this has increased the risk. So causation was not an issue. The case failed in the end because the court found that the increase in risk over a time span of 30 years of only 1% was not high enough to fulfill the criteria of an imminent impairment under that provision in the German Civil Code. So they simply said 30 years, 1% not high enough. Now here again, science could have maybe provided evidence to say over these 30 years, this risk factor will not be stagnation. That they will not be stagnant, they will move, they will maybe increase. It will become more risky as greenhouse gas emissions accumulate. And this is not the fault of the judges. I think it's really a fault of lack of this communication from the very beginning of filing a case, saying what it really entails to take the science into account. Because it's one thing to say that, and it's another thing to really define how the science needs to be taken into account. So I think there are little tweaks, and we can learn from that to better understand how science can drive these responsibility issues forward. Thank you very much. Oh, so sorry. No, I was...
Thank you so much. So now we can move to Hala for the third and last question. So how can voluntary leadership and the regulatory obligation coexist to accelerate impact and fairness?
Thank you for your introduce our moderator, and thank you for all to be with us in this session. The first of all, what I hear now from my colleague actually is very impressive to continue in the same pathway, because we are working in the civil societies and with the companies sometimes to enhance more and more accountability measurements, to be more working from the voluntary as a climate work, from the voluntary work to more and more to be ensured in the right way. When we are talking something about Jordan, especially the climate issues in Jordan, it's not like something funny, because we are a worst country in the water around the world. It's no resources, drought seasons, and many affected in the agriculture, economic, and in the people itself in this. That's why the climate issues, we need to more and more data. And this data actually come from the ground. And the civil society always, CSOs, NGOs, have the access with community to collect this data and work to be more evidence, like what you say, my colleague, to be more and more working in the evidence issue. It's not just emotional statement. That's why we are working more and more with government and with cooperations with the business sector, with the private sector, just to say the climate, it's not only about carbon emission. The climate issues is about water, health, dignity, people's ability to live and to be more safety. That's why the shift from voluntary work action, it's just to think, the climate issues is voluntary work, and we can write some of report by voluntary, by our efforts without any push from the to be more serious. We need really to redefinition, to put the definition of the accountability and transparency in the heart of the negotiation here. And after we come back to our countries, we need to more and more accountability to what our government do. This work, it's not can happen without to be more understanding how to the climate issues affect in our life. That's why in our association and with the cooperation with many network in Arab world, we are working to think about the workers as front lines in the climate issues. These studies show us many actual truth about them. They are sometimes have suffered dehydrations, many work without protection protocols. Many workers lose their economic issues, their education affected by climate change. these truth issues from the ground tell us how we can company they are invest this worker in their work, how we can talking about it's not a net zero issues in the climate change talking. We need to talk about workers facing injustice, injustice, hate waves, injustice, loss of water, loss of their work. That's what we are maybe to think about it. And the climate commitment will do not protected people. Now it's not protected people. It's just put them in more and more in the facing issues in the hard way. And we are now working with the EcoCode company, working in Saudi Arabia and in our country to think about how to the artificial intelligence, AI, working to more and more put the risks and the opportunity in the facing the people and working with the people. And our policy paper we are launching here in the COP30, talking 80% of the infrastructure of the global AI coming from the north. This is the one of the truth issues, and we need to think how we can to put the AI accessible for all. That's mean we need to more and more work in that. Climate data also is still in the north. Model of to trained and people to be more know and trained in these issues. Also, it's not enough to put all the risks beside the people in the front. And we need to think about how we can really mobilize more projects and more ideas, sometimes more initiatives to put the people in the front with us in the same table to think what we are know and to put them in the from the front on the table to discuss more about their issues. That's why the digital justice has become a part of climate justice. Today also is the voluntary work. Until now, the digital justice, it's not one of the things we think about to transform, just a transformation. We think to know more and how we can put that in the table also to more inequality in climate, to be more equality and more justice. The final things I want to mention it actual. We need to think about responsibility as climate responsibility action, like action new agenda, as we are hearing in this COP. We need to think about how we can really science come from the NGOs, science come from not just academia. Academia is very important, but sometimes the languages of academia, it's not give us the aspiring for the words and action for the world. We need to put the science coming from NGOs as a one of the pathway we can work together on that. And the human rights perspective, like my colleague saying, until now, climate change, it's not on the circle of climate justice in a human rights mechanism in Geneva. You know, sometimes we have a lot of conventions and a lot of mechanism in Geneva in Human Rights Council working to really put the human rights in the heart of the climate change. We need to work more, and we need to teach more people in our countries how we can do that and how we can work together on that. And actual climate justice driven, you can driven by truth, by evidence. It's not just by sensitive or some of emotional messages. And we need to work in technical exercise to put a question of digital, a question of finance, questions of the right of people to their ecosystem, and how to can really put the natural-based solution in our thinking with the community. All of this issue in our open eyes, and how we can work together from voluntary to more and more put it on the obligations issue in the work with the climate. Thank you.
Thank you for this first panelist. And we have to exchange panelists now. So thank you so much for your wonderful insights and information. So we will now move to the second part of this event, which will discuss about science-based corporate transformation based on lessons from practices. So I'm pleased to welcome here on stage Maria Jorge Urrutia, who is the founder of K3, the Climate Accelerator Program for Chilean startups, Beatriz Frontin from American Bar Association, and Patricia Morales Serra, who is the CEO of the philanthropy Cortes Solari. So for this second part, we have several questions, and I will first ask Beatrice. How are companies operationalizing climate science through science-based targets or internal carbon pricing?
Thank you. Thank you for being here. Thank you to all my colleagues of this distinguished panel. And I was listening to the previous panel, and the first thing that I would like to share with you is that Brazilian, it's moving towards to those shift the same way United States, the European Union is. So the previous panel covered very much this shift from voluntary actions to binding obligations. And I wanted to bring this here to you. We had our Brazilian emissions trading system just enacted the law at the end of 2024. And this will be a mandatory law here in Brazil that companies will have to meet the science-based targets to reduce gas emissions. And we will have cap and trade system. So all the corporate agenda now is really driven to first implementing the law, because the Brazilian system, the Brazilian emissions trade system, it is supposed to be implemented in a 5-year step. So we have a lot to do, and we are looking up to former or established systems. And corporate agenda here in Brazil, it's really now trying to gather all the instruments and all necessary measures to meet science-based targets. So this is a very interesting moment for us, which we are aligned, as our colleague said previously. This is a global trend that no companies or no more other entities can really shade off of this, because we have to meet those targets, and it's science-based. So our system, it will be also driven to meet those targets, because the accreditation methodologies for having the credit, it will be science-driven. And also the measures of measurement, report, and verification process will always have, we will have to have also accreditation methodologies with the government. So corporate system here in Brazil is really catching up with this global movement.
Thank you so much. Moving to Maria, we have 2 questions. What examples show how litigation and policy frameworks are reshaping corporate behavior? And the second one is, what are the challenges in translating scientific uncertainty into actionable business decisions?
Okay, thank you. Well, I first want to start to saying that this COP has been marked by the need to create a path to accelerate the progress towards the 1.5 degrees goal. And it's a goal that can only be achieved with the decision action from the private sector, in my opinion. And this is where innovations become central to the conversations. Breakthrough technologies like, in my opinion, CDR, are one of that can contribute to that goal. And I'm convinced that countries like Chile has the talent, the vision, and also the commitment from the private sector can rise this challenge too. And for example, this panel is a contribution also to bringing visibility to the discussion. So thank you, Cortez Solari, to bring this together, because this is also a contribution to this achieve our shared goals. And as you, I want to say something in a very clear way. For example, for the Chilean view, in a specific case, even let me wait for a second. I want to explain with a specific case. In Chile, we have leading companies that they are using, for example, they are gaining competitive edge by developing new, greener products and service, and demonstrating how, by action, they are contributing beyond the self-regulated climate pledge. But specifically, for example, Chile business leader must view climate action not as a cause of uncertainty, but as a strategy imperative and an opportunity for innovation to secure long-term competitiveness. And for example, a company like Suralis, that is a water treatment private company, anticipate these pressures and voluntarily adopt protocols. They are investing time, effort, and money to co-create with innovation a pathway that also create value for company and climate contribution. And this is, for example, this is how this is relevant, because in terms of the regulation of the and the regulation framework, you work as an entrepreneur, you work with a company that they already know the regulation and that they already know the procedure, you can, as an entrepreneur, as an innovation solution, contribute under these parameters to co-create new solutions. So, for example, this is how we are developing a MCDR solution with a private company under the regulation, under the parameters, and under our common goals. So, in my perspective, a relevant, I don't know, maybe way of being is to get in the mindset of the business leader, policy leader, scientific leader, the entrepreneurial mindset that's called the growth mindset. We need to develop this growth mindset, because always we are going to have uncertainty. Yeah, but in innovation, we are used to have this kind of scenarios where everything, you don't know how going to be your the further plan. But if we develop this growing mindset, I think that is really relevant, because we don't know what is going on. We don't know what we're going on. So if we achieve this together with this growing mindset under the relation, co-creating projects, I think that would be a better way to achieve the goals and achieve this tremendous challenge of contribute to the 1.5 degrees.
Thank you so much. Now we'll turn to Patricia. How can philanthropy support evidence-based compliance and innovation?
Thank you very much, Cecile, for the invitation and the question. It's true, as mentioned, Maria Jose, we have made progress in Chile, but I still consider that we have a long road ahead, considering Chile's productive matrix, still heavily reliant on natural resources. We still have a long way to go before reaching the true sustainability. For another hand, we have another problem, which is that environmental philanthropy remain dramatically underused, and actually only 2% of global philanthropy goes to the climate actions or environmental action. Usually philanthropy finance education, health initiative, but very few environmental initiative. And that's dramatic because we know that philanthropy has several abilities. For example, we can invest in very risky initiative in order to develop pilots and then allow those pilots to get skills in the industry. And this is one perspective that we have tried to develop from Philanthropia Corte Solari, in particular through MERI Foundation. So I'm going just to give a couple of examples to show how a philanthropic institution can do science and then technology and eventually try to develop, well, a prototype that could be used or that could be developed by an industry. But obviously, it means that we need a governance. So in the case of Philanthropia Corte Solari, we developed two initiatives. The first one is the Blue Boat Initiative. This initiative has one single purpose. The purpose is to avoid the collision between whales and vessels because each whales capture 33 tons of CO2, which is the equivalent of 1,000 trees. So after investigate for 12 years the cetaceans in the North Patagonia, we did a kind of a networking and a huge union with the Universidad Politécnica de Catalunya in order to develop a new technology named LIDO, Listen to the Deep Oceans. And we developed this very clever buoy who allow us to detect the whale and to prevent the vessel of the presence of whale. Obviously, the objective wasn't to have 1 or 10 buoy in the North Patagonia belonging to us. The purpose was really to try to incorporate this technology into the maritime industry, which is the first and the main threat of the maritime ecosystem. So when we decided to develop this, we quickly understood that it was absolutely essential to have the government working on this. It couldn't be at that stage a single project from Philanthropia Corte Solari and the university. So we need to include the government, and we need to include the community, and we need to include at the same time international institutions. And this is exactly what we did. We created an executive committee with the Ministry of Environment and Finance. We developed a scientific committee to be sure that all the scientists, experts on buoy and on noise on the sea would agree on the technology. At the same time, we developed a community, civil society working group, which was the most difficult one, definitely, because of the people ask us, why are you doing this instead of fighting against the salmon industry? And we were, yes, it's another issue, but we are working around here. So it was really, well, it was a learning to understand that the civil society has a lot of issues and they really need help right now, you know. And eventually we have an international committee in order to be sure that NOAA is going to be there, EPCC is going to be there, the World Bank is going to be there because we wanted to value the marine ecosystem system of the blue whale. So this is a first example to how a single initiative of a philanthropy in environment means doing science around cetaceans can eventually become a technological solutions to reduce the collisions between the vessels and whales. But I want to be very clear, philanthropy cannot solve anything by itself. So it's obvious that we can help with a prototype, we can help by investing in risking technology, but at the end, it's inevitable that the government need to be there in terms of governance, and we also need, obviously, the private sector. We understood that and understand that the private sector needs proofs, you know, because they need to be rentable right now. So I think this is a really important thing. And the second example that we develop is the Cachalote. The Cachalote is a vessel that we developed in Chile, and it's a union between the ancestral knowledge in vessels and the high-tech technology from Netherlands in order to ensure that this vessel is completely sustainable. It was a big deal to try to show to the rest of the world that it's possible to change the way that maritime traffic works. And Francisca Corte Solari, our executive president, really decided like 7 years ago to starting to invest in the construction of this boat alone, really alone. Well, 7 years after that, eventually when the boat was finished and the cash alert started to live his life, we started to win a lot of prize award because of the sustainability of this vessel. But the thing is, okay, that's great. Now we have the Catalote. Francisca just obtained the kind of Oscars of the vessels for the most sustainable vessels. And this is great. This is a Chilean initiative. This is great. But what do we do to develop those technology in other ship? What do we do to invite the most important maritime traffic industry to incorporate this technology? That's a challenge, okay? So we already have a single unity. Now we can show to the rest of the world that it's possible, but we need to convince the industry. So I think that the first call and the first wish is to invite more philanthropists to invest in environment in general, and in particular in science and technology that could become real and concrete solutions. And also invite them to work very closely to the governments and the private sector in order to allow those innovations to be scalable. Thank you.
Many thanks to our three panelists. We have now to move to the third and final block. So the last part of the event will consider compliance and to collective transformation and how to align incentives and accountability. So I'm pleased to welcome on stage Matilda Lindblad, who is the advisor in the Industrial Affairs Department of Business Europe and responsible for climate policy. Fernanda Abarzua, who is a carbon mitigation analyst at Wood Mackenzie. She's online, okay? And Andres Avila Kerberg, who is the executive director of Polea, Mexico. So thanks to all of you. So maybe we could start with Fernanda, who is online. So it would be easier, to proceed like that. So Fernanda, if you can answer the first question, how can regulatory frameworks and voluntary initiatives complement each other to accelerate credible action?
Yeah, hi. First of all, thanks to the organizers for the invite. I think this is a great question. I'm going to share a little bit of my experience. I work with energy companies, also in the energy sector, and also in the finance sectors, and in the industry sectors. So what I have realized in all discussions that we have had is like, today, companies are in a more like passive attitude than active attitude. And there's three things that I think, or three factors that are key for them to be in that position, right? The first one is like the compliance scheme haven't evolved as fast, as quick as they expected. So for instance, in the last panel, some of the panelists said like, okay, Brazil is implementing an ETS system, right? But it's going to take 5 years to be fully implemented. So we want like private sectors that are able to mobilize this finance to really act now, but they really need signs, clear signs, and certainty from countries, right? Then the second thing is the reputational risk. And we know that in the last maybe 5 years, the companies and the private sector have been dealing with greenwashing, right, and many controversies. And they have been working. There are many initiatives from the private sector, the voluntary carbon market, to improve all the methodologies that they are following, for instance, in the voluntary carbon market for offset projects, also the guidance for like SBTI initiative, giving guidance to company on how to really set science-based targets initiatives, and how now they are including also an option to use carbon offsets. And however, I think that they are still not sure how they can invest and then claim the contributions that they are doing. And I think that governments could help in this regard, mainly, for instance, recognizing all the work that they have already done. For instance, Petra, in the first blog, I think she mentioned that, okay, we need like PACAM, the new mechanism that is going to replace CDM to improve all the methodologies, right? But during these years, there are like registries like VCS, like Gold Standard from the voluntary carbon market that have also worked with scientists, experts, that they have already incorporate new requirements. So it would be great if PACAM and all the like governments, including carbon offset to meet tax obligation, take a look of this type of guidance, this type of types of methodologies, and work based on that. And that also will give like more recognition that these initiatives can help and in a good way and to meet climate targets. And the third one, I think, is like the first question that I received from companies, like what other companies are doing within my sector, right? So I think like when the industry standard is going to change is what everyone is looking at, right? And governments, again, can play a role there. And I think that maybe incentivizing by subsidize and things like that, trying to identify early adopters. So you help the first movers to implement new technology or to invest in offset projects, right? And then the rest will react, because the companies do not want to be maybe early adopters because they believe that is too risky, but they don't want to lag behind. Because what is clear across companies is that this is coming. The big question is when, and what need to happen for the industry as a whole to move forward, right? So yeah, I think I'm gonna end this here, and thank you.
Okay, thank you so much, Fernanda. And we can move to you, Matilda, and with this question. So how can global cooperation ensure that obligations remain fair and feasible across different contexts?
Thank you so much. And first of all, thanks a lot for having me in this panel. It was super appreciated. So from our side, I represent Business Europe. We're a European Business Association representing over 20 million companies across various sectors across Europe. So we have 42 member federations from 36 European countries. And I think this question is crucial, and it's also very, very important being here at COP, because from the European perspective, we have the main framework for the green transition is in place, and regulation is important to provide a clear direction and then predictability for companies and for investors on where we're heading. But our companies are operating in a global economy. They're trading, they're exporting, and same for countries across the world. So having this global perspective is really crucial. And it's one of our expectations and hopes coming into this COP, and has been for quite some time, is that to make sure that we raise the overall level of ambitions, and in particular that G20 countries also commit to clear targets, and most importantly, implementing the actions and the legislations that are needed to implement and make these targets a reality. For instance, carbon pricing has been mentioned before during this panel as well. So Article 6 is super crucial also from our side. We have an ETS in place since a very long time in Europe. And we are businesses usually like ETSs because it's a market-based instrument. The idea is fantastic. I mean, it's based on market principles. You have a
you have a price on carbon. If it's cheaper to, as ideally, it's cheaper to invest in decarbonizing, in buying new decarbonized technologies or fuel switching rather than emitting the CO2. And in that case, you will instead use this money to invest in decarbonization. It's not always like that in practice. We do still have to work on enabling conditions and making sure that the technologies and the economic case is there, but the overall principle is super important. So this is something that we hope to be able to see more of, more domestic carbon pricing that is being adopted outside of Europe. We heard from Brazil just earlier. I think this is a very interesting development. And when we see this global cooperation, also in terms of methodological alignment across various domestic carbon pricing systems and carbon leakage measures, is really crucial. I think I'll stop there and happy to come back and elaborate on some of the things.
Thank you so much. And last but not least, we will give the floor to the civil society, to Andres. I lost my question here. Yeah. So what what next steps or partnerships could emerge from the COP30 to sustain momentum towards systemic transformation?
Thank you for the question, for the invitation, for the colleagues, for the information. I am from Mexico, and we do work from civil society, basically promoting legislation, climate legislation. We do processes that eventually lead to new or updated climate legislation. And as you can imagine, we need to ask, among others, the private sector. And it's been very interesting because, as what has been mentioned here, this thing has evolved. When we passed the first law in Mexico, it was 2012. And back then, I was already involved in these processes. The main battle was with the private sector, with the fossil fuel intensive sectors. They were very against passing the law because what they argued was that the law was basically trigger unemployment. No? 13 years have happened since then. Right now, we're in another process to update the climate legislation, and learning from that lesson and all these years that we have seen how the private sector has matured too, has been more because of national reasons, but also, as you were saying, international reasons, no? That they have to adapt to the markets, how they have been much more active. But still, it's, I think, like our colleagues from Brazil and Chile, no, it's a current work that we need much more involvement from a private sector. And from our work, around 10% of the people that we have asked around come from the private sector. And it's been interesting to hear what their priorities are, and then eventually how we can put that into the law. Let me tell you, we are not just doing the law by doing the law. We are asked by the government to support government to do the process that leads to. So among many sectors, we ask the private sector. And of course, the emissions trading schemes is like a tool that is being put around constantly. Like Brazil, we have a process, like a never-ending process of preparation, and it doesn't happen still. We are still piloting, but one of the main things that this new legislation hopefully will have is a much more robust and clear emissions trading scheme. So that's something that, of course, will involve the private sector. in terms of voluntary carbon markets. It's also part of the reasons that we are working, because maybe you have heard this, some complaints about the lack of transparency in the transactions, and how those who own forests, indigenous communities, they don't get the right price and so on. So the law, what it's trying to do is to provide certitude to buyers and sellers and intermediaries, but not with the goal of over legislating, which is also a problem, no? Private sector has also request through our processes to have more spaces of participation, to have their voices being heard, which I think it makes sense. I have some other interesting topics here. Yeah, what was also told, no, that is commonly addressed from the private sector when you ask with them is how climate policies will not affect their competitiveness, no? Which it makes sense. Anyway, it's been I think an interesting process in Mexico in terms of legislating a new generation of laws. Besides the federal law that we work with subnational entities. We already have passed 12 laws, and you can say it easily, but it's been 5 years of work. And the same, we have found that there is a private sector much more active, but still reluctant, no? Of course, I'm biased, I'm civil society, but we would like to have much more involvement, not from the typical actors, but from other actors. In the case of Mexico, we have also the challenge of the energy sector, which is also state-owned, but the laws are there, the objectives are there. Now, I think what we need to do is to actually implement, which is always a challenge. Thank you.
Thank you so much. I think we can give a big applause to our 3 last panelists. And so we are running of time. I will give the floor to the all panelists if they want to add the concluding remarks before going to the audience for the questions. So I don't know if somebody among the panelists. No? Okay. So we can move. We have few minutes left to take 1 or 2 questions from the audience.
So,
Yeah, just maybe clear or complicated. I don't know, but so, okay. So if there is no question, I think we can close the session, the event. And again, thanks you very much for your contributions, for all panelists, and including Fernanda, who is online, and yeah, and thank you.
Thank you. Bye.
You can stay for the picture if you want, Fernanda. Sorry.